Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me, as always, is Senior Associate from MBK Chapman, Sam Kill. Sam, how are you?
Good morning, Mike. Doing well. Thank you.
Happy New Year to you.
Happy New Year to you.
I hope everybody out there had a great Christmas and Hanukkah and New Year and just a good holiday season altogether. And that's behind us now. Mm-hmm. So now we've got 2026 to look forward to and maybe lose some weight and get in shape and try to follow our New Year's resolutions. I know I have a few that I'm going to work on. Mm-hmm. I'm sure you do too, right?
Absolutely. Long list.
Well, one of the New Year's resolutions that I already started right before the New Year following was that I wanted to try to get myself a little more often to go to and actually respond to some of the comments that we get and questions that are posed either on YouTube or through some of the other mediums that our podcast gets out to. Mm-hmm. YouTube being probably the main one, right? What most of our listeners or most of our subscribers or people that listen to our podcast get it from YouTube. Although we are getting a growing presence on iTunes and Amazon and Spotify in mm-hmm. particular. And so this question actually, or not question, the issue today came to us from one of our listeners named Kimberly. Mm-hmm. And I thought she posed a complicated question in that there were moving parts to it. And although we've touched on the issue, and I'm sure you recognize that immediately when we talked about what this topic was going to be, mm-hmm. we touched on it when we did our episode on bad management companies. Right? Mm-hmm. But we didn't delve into the specifics that she wanted to. And I thought, you know what, this is a great idea for an episode. So I jumped this to the front of a line, mm-hmm. put this right at the top. We have a list of all the things we're going to cover in the next 15, 20 episodes. I jumped this to the top of the line. So Kimberly, thank you. If you're listening, I hope you are. Thank you for posing this topic. But basically, the title that I'm going to use for this, and I'll probably do an article on this at some point, is California HOA Manager Misconduct, What Homeowners Need to Know. Mm-hmm. So today we're not going to be directly talking about bad management companies per se. We're going to talk about bad managers. What makes individual managers bad managers, and what do homeowners look for and how they can solve that problem. Because many California HOAs, there's a real problem mm-hmm. that homeowners have to face that are not, for a change, caused by a rogue neighbor or a bad board. Right. Although when I say bad board, it is a bad board, but it's more of a weak board. Right. You can have bad managers thrive, as we'll talk about today, with weak boards. But weak boards are not always bad in the sense that we normally talk about, right. that, where they have bad dispositions or bad, they behave badly and they're intentionally doing things, whether it's their egos or self-dealing, whatever it is. That's the context of what we usually refer to when we talk about a bad HOA right. or a bad director. Weak directors and mm-hmm. weak HOAs are not, they're bad in the sense that they are violating the law and breaching fiduciary duty, but they're not doing it intentionally and there's no nefarious.
Yeah, no, they unwittingly will exactly. actually cede space to bad managers who right. will then amplify pre-existing
exactly.
problems.
They might be very even-tempered, nice people right. that should be on the board. They just need to do it differently. Mm-hmm. That's what we're going to talk about today. We're going to focus on that. So this explains how manager misconduct is able to thrive in normal HOAs, how to recognize it, and how to prevent it, mm-hmm. okay? And in this episode, I want to focus on manager misconduct itself, the conduct itself, all right? Not general management company
right.
structure, or we're not going to get into the non-delegable duties. That was what we focused on in that other episode that you can find by going into our archive and looking for that. Mm-hmm. So, Sam, when we talk about bad managers, there's a few things, a few issues, or a few bullet points, right, that, mm-hmm. that equal a bad manager, that make up a bad manager, right? Because it's usually, when you see it, it's usually systemic. Mm-hmm. It's not a one-time thing.
Right.
Okay? You don't label somebody a bad manager mm-hmm. if they make a mistake. Everybody makes mistakes.
Correct. Mm-hmm.
All right? It's usually systemic. It's a result of overreach, and they're never isolated. Mm-hmm. Okay?
Agreed.
So they fall into repeatable patterns. And what are some of those patterns that we see? Give me one of them.
Well, one of the patterns is they actually exceed the scope of their role as an intermediary or an agent, and they end up I guess, infusing or interjecting their own judgment in terms of, how to triage, the requests or complaints they receive from homeowners. So that's a common one we see all the time.
Exactly.
Yeah.
They I guess another way of saying what you just said, or is this what you mean? They manipulate information processing. They overdo, or they go beyond the scope of what they're supposed to be doing.
Right.
And we'll get into that. That is a particular one that's very common. And we'll get into specifics about what we mean by that shortly. Right now, we're just kind of signposting.
Yeah.
That's a good one. How about process manipulation? They manipulate the process to their own advantage. Okay? To make either to simplify their lives, to simplify their jobs, or because they get off on abusing the power.
Right.
It's the same ideology that leads to a bad director would lead to a bad manager too. Okay?
Yeah.
Especially if the bad manager happens to be, if it's a small management company and they happen to be one of the owners of the management company, you'll get that. We talked when we were talking about voting abuses and election abuses. We talked about a particularly bad manager who was violating California's HOA election laws up and down and ran, roughshod over the board. She would be exactly what we're talking about, manipulation of the process.
Absolutely.
Okay, and she had personality issues as well.
And the ego component comes into play with those too, because some of these managers, or bad managers, since we're talking about those bad apples, they've been in this industry or business for sometimes decades. And so they will actually have these inflated egos.
My
and they
way or
think
the
they
highway.
can manipulate the process by virtue of just that being seasoned.
And by the way, I work for you, directors. You're my boss, and you can fire me whenever you want. And we talked in that other episode, and we did this in a bad management company too, I think. A lot of these guys have contracts that make it very hard for them to get fired. And I would say those would not be enforceable, because if you have a management company that's causing, because they're agents, right? If they're causing you, the director, to breach your fiduciary duty because they're overstepping bounds and you can't rein them in, you have to fire them. You're in trouble, Mr. Director, if you don't fire the management company. Those contracts that make them unfireable for a period of time, not even enforceable. I would challenge that. Any HOA, and we don't represent HOAs, we represent homeowners, but any HOA that wanted to get rid of their management company, regardless of what a contract said, could do it very easily if they go to their HOA attorney and say, hey, HOA lawyer, get rid of this clown. Trust me.
By the way, one of the most frequent instances of management removal that we see is when we have removals and recalls, and the board is replaced with replacement board members. One of the first things they do is terminate bad managers.
Exactly, because bad managers are not always, but I'll say often, not always, not even most of the time, often or frequently behind a bad board. In other words, a lot of bad boards are bad boards because of bad management, and then you have some bad members or bad directors individually. It usually requires both. The only time, and we'll get to this, the only time you see a bad board that is otherwise made up of decent people is when they're weak. Because that's really the only time you'll have a good board, and I'm using that, I'm going away from our normal use of bad board, right? You'll have good people who have the right personalities and the right temperaments to sit on a board, and they go in with the best of intentions, but they're weak. And they allow themselves to be walked all over by a strong and a egotistical or bad manager. And that's the third one, I guess, is they usurp the decision-making authority by literally, like that example we just used a minute ago from that other episode, where that lady basically cowed the board into doing whatever she said. They were her rubber stamp and not vice versa. So that's what we mean by manager misconduct. Okay, process manipulation, information control, and we'll kind of define these later, and decision-making, usurping decision-making authority. Okay, now that kind of leads us into the next topic pretty smoothly, which is, before we get into all the real-world examples, which we're famous for in this podcast, because that's really what people want. Because they can understand that, right? That takes it into the real world, right? Is why does manager misconduct flourish in the HOAs where it does, and those bad HOAs? Why does it flourish? There are probably a lot of reasons, right? I'll start, and then you'll give me another one, I hope. Okay? I think when you have a weak board, and they come in let's say they're recently elected and they're not familiar with their own governing documents.
Mm-hmm.
Okay? They don't know what the CC&Rs say. And I'm not talking about verbatim, and I'm not talking about being able to cite, well, Section 6 says this. Nobody's going to be able to do that.
Mm-hmm.
I don't care if you've been on the board 10 years. It's very difficult to, those documents are usually well over 100 pages. And come on, right?
Mm-hmm.
But they should know the they should know that, operating hours for some of the amenities. They should know stuff about the watering policies or the parking policy. They ought to be familiar enough with that.
Mm-hmm.
And to the extent that they don't know it verbatim, they ought to be able to pull it up very quickly. When you get directors who haven't looked at their own CC&Rs or their rules or the architectural guidelines in years, that's a problem. I don't expect these people, lay people after all, to know the Davis-Sterling Act. That's not their job, and it's not reasonable. Even we, who are experts in this area of the law, we look stuff up every day.
Absolutely.
I look at the code every day.
Mm-hmm.
I pull up the Davis-Sterling Act every single day. I'm familiar with it. I know what sections to go to. And if I don't remember the exact section, I can find it within a minute because I know generally where it is. Oh, it's in the 4300s or the 5200s. I know that, but I will look stuff up all the time. There's no way a layperson is. But their governing documents, they ought to know the big things, the stuff that comes up.
Mm-hmm.
Okay? So that's one. They don't understand their own governing documents. Give me another one.
Well, another one I think that I think is rather understandable is they're not familiar with the full history of what they're walking into in terms of pre-existing, let's say enforcement actions, or the history of being familiar with various concerns relating to that specific community, which kind of naturally lends itself to deferring to managers because most managers are carryovers from the previous administration. So they'll say, we know we have a book on this, here are our folders.
And that used to be a bigger problem, I think, than it is now because a lot of boards stagger.
Yes.
There are some boards that don't. I haven't seen one in years, but I'm sure
they
have
have some continuity. But in terms of new incoming directors, usually
they have to rely on the other.
They have to rely on that,
yeah.
and this is where the bad managers will abuse that process.
Agreed. I think another one is, and we're not going to get into a lot of detail because we covered this in the other episode, is that and maybe it's the type of person you're talking about. Because of that situation, they tend to delegate a lot more than they should.
Oh, exactly.
So they delegate non-delegable duties.
Absolutely.
And I have an article or a fact sheet. I have a fact sheet on our website, mbkchapman.com. You can go and type in, director duties, and you'll find it. And I go through the non-delegable duties. We've also done some shorts on that. Mm-hmm. If you go into our short videos, you'll find a podcast on non-delegable duties. I'm sure you will. Right. And then I think the last big one would be you get some people, and this is more on the weaker side. You get people that just don't like confrontation.
Oh, yeah.
So the easiest way to avoid confrontation is just to kind of avoid it, right? So they default to whatever management recommends or whatever my fellow directors say, usually, but we're talking about management today. So management, they've been here longer than me. They know more. I'm going to defer. Mm-hmm. Well, no, it's not your job to defer. Your job is to listen and then decide. Surely you should listen to what the manager says, but then the decision lies with the director.
By the way, I've seen that in practice where those types of board members that you're referring to say, oh, we want to just be neighborly. We don't want to do this for our neighbors. It's the manager. It's a manager that's basically pushing for this. And they kind of make the manager be the bad guy when in reality what they're doing is they're kind of abdicating or delegating, and the manager steps into that space and overreaches essentially.
And overreaches because they're actually, and this would be an example where you have a good manager becomes a bad manager because let's say you have a good manager who's maybe not as strong as he or she should be, is facing a much weaker board, and then that manager wants things to run smoothly, so their manager steps up.
Right.
But the manager can't make judgment decisions.
It's not their fiduciary duties.
No, they don't have. Their fiduciary duty is to the board and to the HOA.
It's a contractual.
That's right.
Obligation.
It's not. It's not to and to the extent that they have fiduciary duties to the corporation itself, especially in terms of financials. If they have access to the checkbook to, pay the normal bills. Obviously, they have a fiduciary duty because that money they're holding it in trust, or in controlling it in trust, right? But it's a good manager becoming a bad manager because the good manager is trying to do the right thing instead of saying, well, hold on, I understand that you don't know the things I do, I'll explain them to you, but you guys have to make these decisions.
Yeah.
I'm going to do what you guys tell me to do, but you guys are the ones that have to pull the strings.
By the way, a good manager in those instances, and not to digress, would also signal to that board, including new incoming board members, hey, reach out, or I recommend we set up a board orientation through your legal counsel to help you with that transition.
Yes. I think we're going to cover that later. If we have time, we'll cover some of the things that would avoid some of these things. And one of those things, let's handle it now. We can handle it now. Some of the things that can be done to avoid the situation is there are some books out there. There's a blue book out there that is supposed to be written for like incoming directors, and often the HOA will purchase those books for incoming directors, and that's a decent book. I also recommend my book, HOA Hell, Amazon bestseller, available on Barnes & Noble and Amazon.
Congrats, yeah.
And it is, I think, does an excellent job helping directors, new and old, make sure that they are avoiding the pitfalls and the problems.
Agreed.
This book basically is an instruction manual on how not to be a bad HOA.
And by the way, you and I have not discussed this. Again, congratulations on all the success with the new book. Here's what I'll say. Even a member who is positioning themselves to possibly running for the board, if they have a book such as this, that is a comprehensive guide, cover to cover, and they go into it as an informed homeowner or member, makes a huge difference because it's a tectonic shift in terms of their perspective. They can go in well-informed and they can help the rest of the board transition and be much more effective.
100% agree. Yeah. I think that's great.
Yeah.
So that blue book that's out there, I used to buy it every year. Now I buy it every couple of years, but I only buy it to see kind of what it is that's been given. But my understanding is that book is often recommended by we talk about the big law firms that represent homeowners, or that represent HOAs in California. Yeah. They often recommend this blue book. I don't know if that's the official name, by the way, but it is blue.
I forget the official title, but I know exactly.
Yeah, but it's supposed to be given to directors to read. Another thing is, we kind of mentioned this before, is they should read their governing documents carefully. Maybe they should listen to our podcast episode about the parts they can ignore. Remember the CC&R, the episode we did on the parts of the CC&Rs you can ignore?
Yeah.
And just focus on the ones you shouldn't, but they should be familiar with the ones you should.
I'll add one more to it because we've done at least, I want to say perhaps 2 episodes on this, and that's the hierarchy of the governing documents and the interplay between the governing documents and other source of authority.
And we've done episodes on that, and there's articles on the website, and my fact sheets, they're all on the website. But you've got the law, right? You got the law first. But as to governing documents, you got your CC&Rs, you got your articles and your bylaws. Those are kind of equal, but the articles are for mutual benefit nonprofit corporations, which HOAs are. When they are incorporated, they're a mutual benefit nonprofit corp in California. The articles are often irrelevant for governance.
Correct.
So skip that. The bylaws are sort of the book that the umpire would have as to how the game is to be played. The CC&Rs and the rules are the players' rules.
Yeah.
Okay. What players are allowed to do and not do. Okay. So CC&Rs are on top. Articles/bylaws. Articles are irrelevant, so the bylaws. And then next, tied, to the extent that your HOA separates its rules from architectural guidelines, those are considered on the same level.
Right.
So rules/architectural guidelines are third place, okay, as the governing documents. And that really covers the governing documents as we sometimes they're called different things, but that's the basics, okay? So what we've got a director who comes in, doesn't read, isn't familiar with their own governing documents, hasn't read that blue book, okay? Or they erroneously over-delegate to a manager, or they want to avoid confrontation. They want to be neighborly, as you put it. That's how bad managers can rise. Because a strong board that's familiar with the governing documents, that's familiar with the basics in the law, what the blue book tells them, isn't going to ever allow a manager to walk all over them, ever. It's just not going to happen. They're going to say, whoa, whoa, whoa. The first time an abusive manager like the lady we've been talking about in that Inland Empire HOA, first time she tried to assert that type of authority, they'd have a meeting and say, we've terminated you. Bye-bye. Well, I have a contract. You can't terminate me. Yeah, get your lawyer. See you later. We're comfortable with what our lawyer told us. Take a hike. So that would never happen with a strong board. But with a weak board, oh, we want to be neighbors. We don't want to cause ruffle feathers. We want to rock the boat. That's a recipe for a bad manager to step in. So an unethical bad manager will exploit those weaknesses.
Oh, yeah.
They'll come in, and then give me one of the ways that a bad manager, sensing the weakness of a weak board, will come in and exploit that. What might a bad manager do? For example, I'll give you one, and then you give me a second one. Okay.
All right.
They like to control the information that reaches the board. They act as a gatekeeper. Now, in normal circumstances, that's perfectly acceptable. These board members are volunteers. They have, for the most, unless they're retired and they're doing this in their retirement years, like we have a couple of retired people on our board in my neighborhood.
Yeah.
Great. But others work. They don't have time to handle I don't know, depending how big your HOA is, dozens, hundreds of emails that come in per month. Obviously, a lot of that stuff gets done by the manager, and the manager's job is to sift through it and bring to the board's attention things that require board attention. So we have no problem with that kind of gatekeeping. That's how it has to work. That's efficiency.
Yeah.
What I'm talking about in controlling information is withholding information that a board needs to have.
Yeah.
When there's an issue that has risen above the pay scale, or the proverbial, you've exceeded my my pay scale here. Okay,
the threshold of day-to-day routine management,
and they hold on to that so they can gain control. That's what I'm talking about. So controlling information improperly.
Like
okay?
for instance, omitting important context or details about, let's say, a complaint they receive, and they kind of cut and paste selectively.
Or not even saying it at all, just handling it themselves.
Right, exactly.
Exactly.
Yeah.
Okay.
Well, another one that comes to mind, and I've seen this quite a bit actually, both in terms of ongoing cases and consultations that I do, is where management infuses some arbitrary procedural hurdles.
Yes.
They just kind of come up with it, kind of, whether it's
their own
spontaneously,
administrative barriers.
Oh, this is not how we do it, or this is not how it's done, and then basically, that kind of gives them some element of latitude in terms of what they like to do next.
They come up with their own administrative barriers, and often it's couched in words like, "Well, that's not how it's done." In terms of, "Oh, director, let me educate you. That's not how it's done.
Yeah.
Okay, this is how it's done. Here's how it needs to happen." No, I'm sorry.
And that can sometimes be intimidating and forceful when it comes to inexperienced layperson volunteer directors who are on the board. Yeah,
of course.
Yeah.
So that's exactly right. Okay, they frame certain issues as administrative details or administrative barriers, and they're creating out of whole cloth. By the way, there's nothing in the law that sets that in motion, and nothing in the governing documents that sets that in motion, and yet the director's been told and believes, I guess that's how we have to do it. And it takes the decision-making completely out of the director's hands.
Right.
I like that one, yes. They've come to expect the directors, they'll draft enforcement actions and expect to be rubber stamped by the board.
Yeah.
Okay, the rubber stamping should never, ever go that way. Rubber stamping should never go either way, if we're being honest. But it should never go that way. Unless we're talking about minor, truly administrative issues. Like, all right, bills were paid? Yes. Okay, that's a rubber stamp. Yeah, all right, I accept your word on that. That's a rubber stamp. I'm okay with that.
Yeah.
Okay? But enforcement, discipline, no.
And that arguably runs afoul of Civil Code 5850 and 5855.
I agree.
Yeah.
I agree. And we covered the gatekeeper issue.
Yes.
But I want to be more specific. Gatekeeping actual homeowner complaints. So a homeowner is seeking something from the board, but it goes to the manager, and the manager doesn't pass it on. The manager takes it upon him or herself. That should never happen.
Right.
If a homeowner wants something to get to the board, it should be part of the board packet at some point. Okay. It might not be that the HOA directors are going to reply. They might instruct the manager, here's how we want you to reply. That's great. That's what they're for. But it should never usurp directors entirely.
By the way, we see that most frequently abused in cases of engaged homeowners or those who are rather informed and they have a volume of correspondence across numerous issues. We see those bad managers in those instances kind of rise up and then kind of pick and choose what they wish to pass on to the board,
which is that
versus
selective
what to omit.
gatekeeping.
And,
Exactly.
And so just because someone is quote unquote frequent communicator because they're either informed, they've done their due diligence,
or there's problems in the HOA and they're calling them out.
Let's say our audience members, people who are well informed and they get good substantive information through our various things that we publish, and they go and seek to hold their board to account. And then you have managers picking and choosing what they pass on to the board versus what they just throw in the trash bin.
Right. I guess another one, and I'm not sure if we had talked about this in our conversation before. Another one well, I guess we'll get to it shortly. It struck me that they'll often play games with what the law requires in terms of deadlines. For example, let's say you're doing a 5200 document request. They will be the stick in the mud that stands in the way of, I'm asking for member information, I'm entitled to that within 5 days. Mm-hmm. I'm asking for this year's financial, I'm entitled to that in 10 days. Or I'm asking for last year's financials or check registers, I'm entitled to that within 30 days, right?
Yeah.
Under the 5200 statute. And, we can't seem to locate that for now, or you're going to have to wait until we find it, or you're not really entitled to that, I don't think. Show me why you're entitled. It's like, and it's obvious that
or
you
for
are.
the membership list one, for example, I've seen this actually.
Tell me why.
Proper cause. Just kind of.
And proper cause is easy.
Yeah.
As long you can say this for proper cause. I want to reach out to all my fellow homeowners to start a petition to recall the board so that we can have a new board appointed and then fire your company.
Right.
Well, that's not a proper cause. Well, yeah, it is actually. Yeah. It's exactly a proper cause. Mm-hmm. Yeah. So I think we'll get to that later. But that struck me as one of the things that happens. But bottom line, you get these bad managers will jump in and they'll utilize this, making up administrative barriers. They manufacture authority out of whole cloth. There's another one, right? Yeah. They just manufacture authority. They put upon themselves the power and the right to do X, Y, and Z, regardless of what their contract with the HOA might say or what the Davis-Sterling Act might say. For example, you kind of touched on this when they come up with these certain procedures. If those procedures violate the Davis-Sterling Act, let's talk about the operating rules. 4340 to 4350, right? Mm-hmm. Those are the parts of the Davis-Sterling Act that deal with rules. Or 4340 and 4350, I think is a better way to put it. And they violate those provisions by putting on themselves power they don't have. Okay?
You mentioned at the outset how this is recurring and systemic. And a lot of these transgressors, the bad managers, they've been doing that for so long that at least with them, it's this entrenched standard operating procedure. So they keep recycling the same narrative over and over.
Yes. So they manufacture. They do the records. We talked a minute ago about the records violations, right? Mm-hmm. They make stuff up. They redact when they shouldn't be. The only time that you should be redacting on a 5200 demand is if it's privileged or otherwise confidential. For example, let's say there's stuff about other homeowners in something that you're otherwise entitled to. They can redact information about homeowners in that.
Yeah.
But there's also a code section, and we talk about it in my book, and in the multiple episodes we've done on 5200, and in the multiple articles we've written on the website about 5200. Mm-hmm. There's that 5215, 53 or 5215D. I think it's 52.
5215. Yeah.
5215D, which you should always include in your 5200 demand, which is, to the extent that you withhold or redact any records, please provide the reasons you withheld and what it is that you redacted.
Exactly.
That doesn't mean they have to give you the private information. They could just say, we redacted some homeowner confidential information. That's all they have to say.
Right.
They don't have to say, we redacted the fact that we punished, this person for doing that. That would defeat the purpose.
Yeah.
So they misuse that. Another way it manifests is what I like to call enforcement by proxy. Okay? That's where they decide which violations proceed to the next level, a letter or a demand for a hearing, and which ones don't, or which go to the board and which ones don't. To the extent they have buddies in the community, or maybe even a director, violation that they might notice on a walk around or a walkthrough, they ignore it. Whereas other ones, on somebody maybe a frequent communicator to the board, they're out. They have an eagle eye for that person, right? And that leads to all the things we've talked about in other episodes: selective enforcement.
That's a good one. Yeah.
Right. And then the rendering the discipline in the hearing process and running those differently. 5850 and 5855 civil code, right? Mm-hmm. And we've got, for example, you've gone to several. I know in particular, We've had clients that have hired us to attend a disciplinary hearing with them.
Yes.
You once did a famous one because they had the HOA lawyer there.
Two of them.
And two of them.
Yeah.
Okay.
Yeah.
Two members of that law firm, and you schooled them and basically embarrassed the lawyers in front of the board.
Felt a little bad, but
no.
But
see,
great for our clients.
Never ever feel bad about that. You did your job and you did it well.
Yeah.
But have you ever because I'll give you my opinion on this after I hear yours. In all the hearings that you've attended with our clients, have you ever seen a director, because you would have shut it down, I'm sure. Maybe I'm giving you the answer here. But have you ever seen a director? Not a director, scratch that.
A manager?
Have you ever seen a manager posing questions?
Yes.
Yeah. And
yes.
What do you do when that
Several
happens?
times. The way I do it, it really depends on the content of it. If it's something that
I can't wait to hear this because I'll tell you how I do it.
If it's neutral or if it's something that potentially is something I can use to our advantage, I let it go on. I mean, organically, to the extent it can be used.
You're doing strategy.
But
strategery. Got it. Yeah.
And I'm trying to kind of navigate it tactfully where I don't want to necessarily alienate the board or
I get it.
the
Go
people
on.
I'm dealing with. That said, most of the time, I respectfully and as tactfully as humanly possible shut it down
nice.
and kind of bring in either their legal counsel or present or reframe and pivot to the directors.
This is why I love Sam. And this is why you are a senior associate at this law firm and you're so trusted, is because you're the one I go to when I'm hot and bothered and I'm writing a letter either to another lawyer or to a homeowner that doesn't have, a rogue neighbor or even a directors directly that I don't know who their attorney is yet. And I need the letter to go through a gatekeeper first to make sure I'm staying completely professional. You're the one that I will read the letter to or let read the letter. And then
I appreciate that, yeah.
I invariably wait for I would tamp down this part. I always wait for that because I know when I need to go to you. And so there's always something.
Yeah.
There's a reason why I'm going to you. I'll now explain what I've done when that's happened. So here's how I've handled that when it's happened. And it's pretty rare when it happens, at least when I've been there. It's rare. It's not rare when there's no lawyer for the homeowner there, but it's happened a few times. And yes, if there's a strategic reason to be silent, because it's actually what's happening is benefiting my client, then absolutely I keep my mouth shut. But that's often not the case. I shut it down very quickly, and I'm not subtle about it, and I'm not nearly as tactful as you are. I go to embarrass the manager and the board for allowing it. I just think that's fun. So that's my personality.
Yeah.
I point out how desperately stupid and unintelligent and inexperienced a manager has to be to think that they have a right to open their mouths during a disciplinary hearing. And then I cite the code and say, perhaps you should take a 5-minute break and go read the code. Even though you're not a lawyer and you probably won't understand what you're reading, try. And then we'll come back and we can have a conversation. But you need to shut your mouth and let these elected directors guide the conversation and grill my client, so to speak. You can advise your client, the directors, on procedural, administrative issues, but you are not a decision maker here, and you're not a prosecutor, and you should keep that trap shut.
Can I be off camera on your next one that you participate in?
I don't handle day-to-day cases anymore, so it'll never happen again.
That would be entertaining.
There will never be a day where I will attend a disciplinary hearing with a homeowner.
Okay. Yeah.
I'll just send you.
Yeah.
Or Sarah or whoever else.
Yeah.
Okay. So let's kind of wrap up this list of these behaviors we're talking about and these bad managers. Another one is, and it kind of flows into what I was just saying, is they overstate either the HOA's legal position or they cross the line into giving legal advice. These managers are not attorneys. I've never met a property manager that was actually a licensed attorney.
I haven't either.
Never. Not happened. Okay? They are not allowed to give legal advice. And they certainly shouldn't be advising the board on legalities. It's one thing to say, hey, guys, you can't do that because the Davis Sterling Act says that's not allowed here. Take a look at the Blue Book here or whatever. They're allowed to do that.
Or copy and paste from legal counsel.
Exactly. Yeah. Okay. But they cannot give opinions about what the law is or isn't, or what, well, courts have ruled this way, or this is a murky area, so here's kind of how, you can't do that.
Yeah.
It is a fine line, but these guys don't walk the line, they just cross it. So they overstate, for example, a legal position. They'll make something up and say, well, the board can't legally do that, which is why you're getting disciplined here. Mm-hmm. And it's just not the law.
Yeah.
It's not true.
Mm-hmm.
Or they'll either negligently or intentionally misstate the governing documents.
Okay? I've seen that, yeah.
Yeah. Well, we've seen it in two ways. One way we see it is when it's intentional. They know what the governing documents say and they say the opposite, counting on the fact that homeowners don't know. And then another way we see it is when there's been a law change and there was supposed to be a change in the governing documents so that something that was legal and enforceable in the past has become illegal or unenforceable because of a law. And we talked about that in recent episodes, where you have a change, let's say in election laws, or a change in the solar, some of the solar laws, right? Where old sections, or even, here's a good one from a few years ago, when they changed the rental laws, the short-term rental laws. One of the requirements was that the governing documents be updated to reflect the change. Now, a lot of HOAs haven't done that.
Yeah.
And there's no penalty for that necessarily, but those provisions are no longer enforceable. But you have managers who know that and are still citing those sections. Mm-hmm. That's what we're talking about.
Yeah.
Okay. And they substitute their own judgment for the boards. We talked about that one, right? Okay. So, I would close this part out by talking information control is normal, right? But information distortion, or information overdoing the gatekeeping, right? Preventing the board from getting things that they are required to be deciding. That is misconduct. Okay. Now, on the kind of the last big topic area of this issue is the meeting/minutes/agenda abuse. In a lot of HOAs, the person who takes the minutes in the board meetings is the designated manager.
Yeah.
Okay. It's not always, but it's very frequent. And you can do a lot of damage if you're a bad manager.
Yeah.
So let's talk about what their playbook in this arena looks like. Okay. What does it mean? And I'm sure we've heard this. It's not ready for the agenda yet. So a homeowner makes a request to put something on the agenda. We might as well cover that. Tell me about that for a second. Does a homeowner have a right, if something's important to the homeowner and it's an issue, does the homeowner have a right to request that the board add something to the agenda so it can be discussed in an open meeting?
Oh, absolutely. Absolutely. Especially if it's something of community concern, something that is likely to be, pertaining to multiple members or membership rights, or something relating to, let's say, common area, which happens all the time, rights and responsibilities in terms of, maintenance obligations. Absolutely. So to say or to claim that that is not yet ripened into something that's ready for the agenda, or, we're still
always have a discussion.
Yeah, no, absolutely.
Because remember, folks, at a board meeting, other than the open floor, which is usually at the beginning of the open board meeting where homeowners are given a certain period of time, a minute or two to talk, and it doesn't have to be agendized, right? That's open floor. You can't discuss or make decisions. The board members, the directors can't make decisions on items at a regular board meeting that weren't on the agenda.
Right.
Okay, they have to be agendized first. And in a situation where you can always discuss something, you can table for future.
That's
you
exactly
you don't have to have every discussion does not have to result in a definitive decision.
If you need consultants, if you need to investigate, you can always table and get more time.
Right. Or you know what? We need more time to discuss this, but it's getting late now, so why don't we table this for the next meeting and we'll pick this back up. So does a board have to, every time a homeowner says, I want this added to agenda, does the board have to do it? No. The board does not. The board can control their agenda. But it is very dangerous for a board to refuse to add an agenda item requested by a homeowner if that agenda item relates to something that is important. that relates to a misuse of power or misuse of finances or a question as to whether a law was violated or a procedure was violated, it would behoove the board to put it on there. Because if that homeowner escalates and we were to get it, for example, and find written requests and emails to add things to an agenda and it was never added and they should have been added, that's going to come back to bite that board. And so even though the board doesn't have to listen, you should always ask. Just don't do it frivolously because you lose credibility. But that's what that means. Let me give you another one and you tell me what it means. Well, that's an important issue, homeowner. Thanks for giving it to us. Why don't you direct that to the manager and they'll make the decision on this. We hear that.
So it sounds like that was presented to the board, and then the board just kind of redirected them to the manager, which is an improper delegation.
Wouldn't discuss it at the meeting.
No, that's improper, and the manager does not have decision-making power when it comes to that. The board absolutely does. So if presented to them right there and then, they sua sponte have the ability to address it, take it on, and if they, like you said, need to table it for a future, hey, we need to discuss it with our legal counsel or consultant such and such or investigate it.
For example,
it will circle back
if a director
Yeah.
sends an email to the manager saying, I want you to add this to this issue to the agenda. The manager needs to add it to the agenda. If the manager decides, no, we're not going to do that, and it doesn't get added to the agenda, the board can't discuss it, even though the director had wanted it there.
Right.
That manager who's now usurped that board authority.
Correct.
Because that director wanted the fellow directors to have that discussion.
Mm-hmm.
Okay? Another one, you hear this from really bad managers, is the board doesn't need to be dealing with that right now. We've got other things to do. You know, we're dealing with other issues. Mm-hmm. No, that's not your decision, Mr. Manager.
Right.
Okay? Or remember, there's a code section out there that talks about the 5 things that can be discussed in executive session, right?
Mm.
So Civil Code 4935
Right.
kind of lists those out. To the extent that items are not on that list, they can't be discussed in executive session. But how often, and the answer is all the time, how often do we hear either directors, but in this case talking about bad managers, talk about, well, we're not going to talk about that at the meeting. We'll cover that in executive session.
Yeah.
And it's not remotely related to one of those 5 things.
All the time.
Can't do it.
Mm-hmm.
Can't do it. That's extremely abusive, okay? Now, so that's the agenda issues, right? That's how you abuse agenda. Give me one way a bad manager might abuse the procedure regarding minutes. Give me the most obvious one.
Okay.
That comes to the top of your head.
Most obvious one that I have ongoing in a number of my cases right now that I'm handling for the firm. They selectively capture and chronicle one side of the issue and omit the other side.
Yeah, they ignore.
Very conveniently, but it's not. It's more than that. It's not something that's innocent or somehow, it's an,
they take half the notes.
It's very much deliberate by design,
Yes.
and it's to spin, sometimes to shame one party openly in those minutes.
Well, it's to spin a narrative.
Right, to spin a narrative and to justify their decision-making. So they completely omit context. They omit the other side that's inconvenient to the side that they're covering.
So that falsification of the narrative is exactly what I was hoping you were going to bring up first. They don't take proper minutes because they only note or journal one side of the issue.
Yeah.
If a homeowner poses a difficult question and says, this needs to be addressed, when I have a problem with this, that homeowner should be identified in the minutes. Is this person raises it? Or if a director, if one of the lone directors is going against the tide.
Right.
And that should be reflected in the minutes.
Yeah.
Okay? And when you have them just, no objections came, or there was an objection, but it was addressed, and there's no detail, nothing.
Sound arguments made that basically brought to the board's attention and put them on notice of all their fiduciary and legal duties.
And never made it into the minutes.
None of that was memorialized. Just some arbitrary
Mm-hmm.
caption, and then the flip side of it, of how they did everything up to par, is then itemized.
That is a huge problem. It happens all the time. And the easy solution for the homeowner let's say you're the homeowner that brought up the whatever issue, is you request the minutes 30 days later, because remember, Davis-Sterling Act requires the minutes to be available to all the homeowners within 30 days of a meeting. Mm-hmm. So you wait your 30 days and you request a copy of those minutes. Now, some HOAs automatically post minutes on a certain website or whatever, but the law doesn't require that, and that there was a law up for debate, but it got killed in committee, so that never passed.
Yeah.
But you wait your 30 days and then request those minutes. You then look at them and find it's all gone. None of it's there. Here's what you do. You're the homeowner. Here's how you fix it, because they've now crafted the narrative one way. You prepare a detailed email to the manager and every member of the board that you know their email address to. And you point out, we had a meeting on X date. We had a meeting on December 15th. I've now read the minutes. And what I noticed was missing from the minutes was the 15-minute conversation that we had on the agendized item of this issue. Everything I said during that meeting, all the points I made about how the board was doing this wrong, or how this was a violation of the law or violation of our governing doctrine, whatever the case was, you left all of that out of the minutes. You created a false narrative. This email corrects that narrative. Here's what actually happened. HOA asserted this. I argued this. HOA asserted this in response. I argued this. That's what happened. I just wanted to set the record straight and giving you the benefit of the doubt that you just turned temporarily deaf for part of our discussion. I think you should amend the minutes. But if you don't, this is my narrative. Mm-hmm. You correct the record. I don't require them to respond that they received it. Who cares? As long as you can show you sent it, that's all we need. Mm-hmm. That is worth its weight in gold. Okay? That is one big abuse, a minutes abuse. You're absolutely right. Okay? And here's another one. They cover both sides, right? But the minutes are so hopelessly vague as to give no context or facts behind anything. Mm-hmm. So they might be something like, homeowner brought up an issue about spending, discussion was held, and an agreement was reached. That's not an effective minutes.
Right.
You need to identify the issue. You don't have to, it's not a transcript. Nobody's asking you to be a stenographer and to have the powers of the stenographer who can take down literally every word that's said.
Yeah.
But you have to capture enough detail so that 2 years later or 6 months or 3 years later, if there's an issue, somebody can go back and see what was discussed or decided at that meeting.
Exactly. Mm-hmm.
And I'll remind you, we're talking about minutes for open meetings or agendas for open meetings, but minutes are required for any meeting. Executive session, there has to be minutes. There has to be an agenda, okay? Even committees, unless a committee has a quorum of directors, if a committee's been given authority to act, then every committee meeting is an open meeting that homeowners can attend and watch, not participate in, but watch, and minutes must be kept, and an agenda must be kept, okay? So keep that in mind, because another one of those abuses is they skip that. Yeah. We are in litigation right now with an HOA who almost does everything wrong. Now, it's one of those small ones, under 10 homes.
I was just about to say,
yeah. It's one of those small ones, and that's when you see, when you're getting 98% failure rate, it's usually a very small HOA that just doesn't have the interest. And it's like, it's just us. Why should we follow the law? Well, you have to, even if it's 9-1.
Yeah.
Okay. So we have a case right now where among the many things this HOA has done wrong is there are very few sets of minutes for meetings that have been had and very few agendas, even fewer agendas. That's completely illegal. Okay. And the manager is as inept as the directors. Here you have both.
Oh, they have a manager. Oh.
Single manager, a one-man company, and the man does not know this area of the law or governance. He has no idea. And I know that from the things he's written.
Yeah.
It's literally the blind leading the blind and dumb. Okay? So I guess we can narrow down or narrow down this issue with the minutes as they either misstate what happened, right? Just straight out misstate it, create a false narrative, or they ignore one side, another way to create a false narrative, or they're so hopelessly vague as to render the minutes useless.
Right.
Those are the three biggest ways that...
In a sense, that's spinning and framing.
Exactly.
Yeah.
So what do we hear? You know, directors will have these phrases that they like to use when they're called out on that. You find out there are no minutes or there are no agendas or the minutes are woefully inadequate. We didn't know.
Yeah.
Or well, we didn't discuss that. Or oh, issue was never raised properly. Those don't work.
No.
Those don't work. Okay. Bottom line, folks, bad managers are out there. They thrive in environments where there are weak directors, or in worst case scenarios where you have nefarious directors who are intentionally committing wrongdoing.
Yeah.
But it is easy to spot the bad managers, and those are the ones that have taken decision-making upon themselves, or who are preventing the board from getting emails or other writings that they're entitled to get. If they're gatekeeping to the point where they're excluding you from being able to reach your board, they're usurping the law, and they're violating their authority under the law. Okay, and you can do a lot to prevent this. You can demand records and show what's missing. There's nothing better than a set of badly done minutes to show that minutes are done badly. Okay, you would send those emails out to correct the record. You can go for recall. Okay, recalling, when you're recalling an entire board as opposed to individual board members, is actually not difficult to do. It only the petition itself requires 5%. That's a very low threshold. Okay, then yes, there has to be an election, but when if you're going after the whole board, you don't have to deal with the issue with cumulative voting.
Right.
So there's a lot you as a homeowner can do. But the first step in fixing the problem is recognizing it. And we've given you some information to recognize. If you like this episode, please hit the like button. And if you haven't already done so, please subscribe to the channel, HOA Hell. If you have any comments or you want to leave a question, as always, please do so. We love to hear them. Until next time, have a wonderful day.